Good morning, everybody, and thank you for joining us for yet another webinar. For those of you that are not aware of what the TESD is and where we fit in, the TESD is a part of CEA, which is part of the greater CIFSA associations. And the TESD specifically looks after the temporary employment services companies that work with in the industry. And our main aim is to ensure that we have compliant TES providers to clients, and trying to give clients the assurance that the TES companies that they do work with are compliant, they are vetted, and they're above board to ensure that clients also remain within the confines of the laws. So this morning's webinar will be handled by, sorry, I just want to get this thing. This morning's webinar goes around the National Labour Migration Policy, and we've all seen the write-ups in the paper about foreign nationals working in South Africa and the changes being made to these laws and provisions that were made for us to allow to employ foreign nationals within our businesses. Natalie and John are from Global Business Solutions. John, I've introduced you so many times, I'm going to keep it short and sweet. So John has been a specialist in the workforce strategy for many, many years. He's worked for global workforce solutions businesses. He's a negotiator at NETLAC. He represents South Africa at the ILO and the ILC on 3 occasions previously. He's got a BCom honours degree in postgraduate diploma in labour law and a certificate in design thinking from the MIT in the US. All right, he brings many years of experience within not only the temporary employment services and workforce solutions businesses, but also various other employee-related areas of speciality. Now, Natalie, to introduce Natalie, Natalie's has more than 12 years of experience in talent management. She's run her own recruitment business and headed up the staffing professional body called APSO from 2007 to 2014, including representing Africa on the World Employment Board. Natalie is expertly positioned to empower organizations to understand and adapt to the 21st century world of work. She continues to be actively involved at an industry level and therefore familiar with the ever-changing legal and regulatory labor landscapes. Natalie prides herself on her ability to take complex theory and turn it into pragmatic and easily implementable business-focused solutions. And I think for all of us here, I don't think anybody in this forum at this stage can say safely that we do not have foreign employees. And I think, Natalie, John, it's over to you to explain to us all of these developments, how it will impact our businesses and how we can safeguard our businesses to maintain profitability, longevity within these trying times that we live in.
Thank you very much, Albie. Good morning, everybody. Thanks to Albie, Krista, and the leadership of TSD. We always are keen to collaborate with you. I'm just going to say a few words before I hand over to Natalie. What I really want to say today, colleagues, is in my mind, we are facing 3 massive disruptors to the labor market that is going to result in the displacement of, I think, between 1 and 1.5 million people in the next few months and years. The first one, of course, is a topic for today, the National Labour Migration Policy. And I'm not sure anyone knows exactly how many foreign nationals we have in South Africa. I did take a look at the Employment Equity Commission report, where, as we know, more than 50 people or companies employing more than 50 staff have to report. And there are about 200,000 foreign nationals registered in the EEA2s that are submitted. That's 200,000 foreign nationals across all occupational levels. And I think if you then included less than 50 employees size companies, you're going to look at least double or even triple that amount. So we're looking at between 500,000 and 700,000 workers potentially. Natalie, I'm sure we'll get into the details. So that's the first big disruptor. And I mean, you can just imagine the opportunities that it creates for you in the context of your clients, and Natalie will take that forward. The second big disruptor, of course, is the employment equity ministerial targets, where the ministerial targets will clearly drive employment practices over the next 5 years, as we have retirements, retrenchments, resignations, dismissals, and changes to the workforce. And then the third large area, colleagues, is platform workers. And platform work, as we know, is growing exponentially. In our estimation, there are between 200,000 and 300,000 direct platform workers that are currently treated, let's say, in different ways according to different workforce models. So we are facing a massive challenge over the next 1 to 5 years, rather. Wonderful opportunity for you. And then, of course, on a micro scale, on the 20th, we see the EFF piggybacking on the SAFTU socioeconomic protest action. So Monday, the 20th, national stay away being called by SAFTU, who are collaborating with the EFF. So no shortage, colleagues, of reasons for engagement with clients and planning with clients. But Natalie, if we just go to the slides I sent you before you get into the meat of it, colleagues, we will be running an employment conference on the 16th of March. This conference is going to be held at the Maslow Hotel, and the focus is really on economic, social, legal, political, and workforce solutions. We'll be looking at mental well-being, workforce strategies, etc. And if you get hold of Cynthia, whose email address is at the bottom, you know, we will extend a discount to you in that regard. So really just highlighting this, and this will give you deeper insight into a lot of the big ticket strategies that we're going to be talking about today. And then, of course, colleagues, we remind you of the massive labor law and workplace legislation pipeline. If you just take a look at the top here, that's the sort of roadmap for the year. You know, we've got the national minimum wage, which has been done and dusted. The earnings threshold has been reviewed. You've got the WSP ATR levy grant regulations that have been published for comment and restructuring a whole range of those areas. We've got COIDA. You smoke a ZOL, well, good for you. You can smoke it privately, but you can only carry 100 grams of it in your pocket, Natalie. I know in Durban poison, you carry a bit more than that in Durban. But nevertheless, a huge amount of legislation coming through. And we just want to alert you to this and opportunities that this presents for you to engage your clients, because the more complex the environment, the greater the opportunities for you in that regard. But nevertheless, I just wanted to break the ice and take Albi's intro a bit further. And Natalie, of course, is now going to focus on the big disruptor, the National Labour Migration Policy. Natalie, we're in your hands. Thank you so much for taking the time. We know you're helping many organizations in this regard. So as your resume said, you take complex issues and make them really, really simple. Thank you so much, Nat. Over to you.
Thank you very much, John and LB and team. It's my pleasure to be with you today. What I would like to do is obviously just start us off in understanding what the National Labour Migration Policy is and what it's intended to do. It has, of course, implications on businesses across the board, but it also has quite specific implications for us in the employment services industry, as other changes to the Employment Services Act which are required to enable the national labour migration policy may also impact the way in which we operate as businesses. So I'm going to cover a fairly broad range of things, and I've hoped in my planning to cover both, of course, the Zimbabwean exemption permits, which I think are going to impact a significant number of employees, particularly as we are fast approaching the 30th of June, which is the current deadline, and how can we assist those employees, or what do we need to do as businesses to compliantly exit them from our businesses if they're unable to secure alternative right to work. But there have been changes too to the critical skills list. Now, in some positives, the secondary gazetting in August last year added back to the critical skills list some of the roles which I think would be particularly pertinent to you and your customers within the engineering and technical space. But the practicalities around accessing critical skills visas have become a lot more complex and slowed down significantly. Also would like to have a look, of course, at how we can utilize the changes, looking at, of course, the risks to our businesses so we can mitigate those as far as possible, but also where there might be some opportunities. And to link into what John said earlier, you know, the sectoral determinations within the employment equity environment is going to drive a need to focus on designated group members. And of course, as we know, foreign nationals are in fact non-designated, regardless of their race or origin. And this is all happening, of course, within the context of increasing pressure on government around foreign nationals. And as John points out, there isn't an absolute number of that we know for sure. I think, unfortunately, many times foreign nationals are an easy target to kind of point fingers at or blame, taking our jobs, etc. And whilst, of course, they are taking up jobs, they're not necessarily taking away jobs necessarily from South Africans. So we have a very volatile political situation, particularly as we run up to the national elections next year. And given the wavering support for our governing party, this is an issue that I think is going to be a politicked one, an electioneering one. Certainly we see the EFF and organizations like Operation Tudula already jumping on this bandwagon around get rid of all foreign nationals from our country because they are the reason South Africans have no work. And I think we're going to see this continuing. But if we have a look practically at what the national labour migration policy is, and from the document itself, and happily we'll share, of course, the slides via the TSD after the session, so please don't furiously write down any notes. You will have access to them, and we'll happily share also the national labour migration policy documentation. But in effect, it is the attempt by government to create a clear direction for the country on how to manage the complexities of our economy. We are cognizant that we have skill shortages which need to be filled. And ironically, we also have a situation where we have a number of foreign nationals working in low-skilled sectors, particularly agriculture, where there is a challenge for employers who are struggling to find locals who are prepared to work and to do certain kinds of work. I was just 2 weeks ago with a client of ours in the sugar industry, and they were sharing that they too today, even despite major efforts to encourage local individuals to take up roles within the sugar cane cutting season, they struggle to the point that they are required essentially by operations to look cross-border, particularly from Mozambique, to have individuals come in for the cane cutting season in order to meet their operational needs. And so there's this fine balance that needs to be struck by government, and certainly I don't think it's an easy job in trying to figure out how we ensure that we remain competitive as a country, that we're able to have the right skills necessary to execute across a variety of industries and complexity of competitive skills levels, so that we are an attractive destination for foreign direct investment, but also how we manage the realities that we are operating within an environment where, unfortunately, education levels are perhaps not as we would hope they would be. Certain sectors, of course, we're not producing enough people with the qualifications and skills we need, or those that we are producing are choosing to take up opportunities elsewhere in the world. I read that I think it's 85% of all actuaries who we produce on an annual basis are snapped up globally within a year. And so we just aren't producing as many as we need, or retaining as many as we need. And to John's point, platform work creates a very unique situation for knowledge workers too. It's no longer even a requirement to emigrate to be able to work for a global firm. And so the fight for talent, the war for talent, that's a great analogy we've used for so many decades, the war for talent continues. And it's not just about competing with local employers, it's now globally as well. I'd like to play a video now. This is Sam Moratoba, who many of you may recognize. He is from within the Department of Employment and Labour. And in this short clip, he provides some insight into the thinking of the department around the National Labour Migration Policy. We are extremely blessed as an industry to have some wonderful industry representatives who have been directly involved in this process, not least of which is Bev Jack, a fellow CAPES member, who is intimately involved in this process, and who, of course, is doing her utmost to present the challenges and the concerns and other issues from an organized business perspective. So without any further ado, let me just share sound, and let's listen to Dr. Moratoba.
Firstly, you have got an employment convention C88. You also have other conventions that were passed afterwards. But the reason for having a national labor migration policy is to have a well-coordinated governance process that can be used to manage the inflow of people who are coming to work, and that you can have proper statistics in terms of the numbers and their location in different companies, so that you can then know the percentages of migrants that are in the country and the sectors that they are working in, and the kind of employment conditions that they are subjected to. And in the process, you can check as to whether there is a distortion that is happening in the labor market. So the labor migration policy basically regulates all those aspects, including the inflow and outflow of citizens going to work in other countries.
So in short, part of the challenge, of course, is as a signatory to the, or a member of the ILO, the International Labour Organization, South Africa has certain obligations that it is required to fulfill in regards to the management of migrants, whether those be asylum seekers or refugees. And then also recognizing that we know, looking at global research, that a healthy migration within a labor market is about 10% of the labor market is seen as being a healthy mix, which enables the transfer and movement of key skills into areas where they're required. So South Africa's labor migration policy seeks to achieve the balance. So how do we manage as government the expectations of the population regarding accessibility to work? We know particularly amongst youth, unemployment is at an epidemic level. And as we see in the fourth GDP numbers being severely contracted, we know that more jobs are potentially at risk. And so it's creating more and more pressure on the system. We also are very aware of the fact that we have certain key skills which we need desperately and which we don't have enough of. So how do we manage that inflow and outflow of employees? And interestingly, I think, as Mr. Maratoba says, is that there is a desire amongst the Department of Labour in particular to have a better understanding of the numbers. And to do this, there needs to be a better management or administration, documentation of employment and how things are working. So currently, those who are in the country under ZEPs, as an example, there is no need to complete any specific paperwork. The conditions of that exemption permit allowed those individuals to move freely within the marketplace, just as you or I as South African citizens could. And so there isn't the same level of reporting and detailing as is necessary. So the key objectives as outlined, well, of course, it's about the attraction and retention of skill to meet both temporary and long-term needs of the country. There is a discussion around the implementation of quotas to limit the number of foreigners in particular sectors. And again, this is one that I think has raised multiple questions around how is this going to be determined and what kind of negative potential impact could that have on sectors where there is a reliance on foreign workers. It's around recognizing that certain critical skills need to be prioritized, and not just in enabling us to bring those skills into the country, but recognizing that for long-term solutions, we need to be funneling that into our skills development environment so that we hopefully can start to build our own skills capabilities in that area. There is a belief that many migrant workers are in fact subject to conditions of employment that are not aligned to our legislation. And whilst I guess there's always going to be non-compliance within an environment that has limited enforcement capability, we also know that many foreign nationals are working within sectors which are properly governed by minimum wages and terms and conditions, and they would be treated exactly the same as any other worker. We have, unfortunately, seen the rise and flare-up of xenophobic attacks, which of course creates a physical, social and emotional risk to migrant workers and their families. And as a member of the ILO, we have an obligation as South Africa to ensure that those individuals are not unduly prejudiced or placed at risk. And then, of course, how do we make sure that we are also able to navigate the complexities of the relationships with particularly our neighbors? So, you know, we don't want to put up walls and fences that are necessarily going to perhaps stop the inflow of certain migration pathways, but which in turn could create some political challenges for us as a country. Now, what I want to focus on for a moment is that the Employment Services Act, which was first promulgated in 2014, and is in fact the principal piece of legislation by which our industry, staffing industry, including, of course, temporary employment service providers, is governed. This is a wider piece of legislation that doesn't only seek to enforce regulation around our industry. And in order to affect the changes that the National Labour Migration Policy is seeking, there will need to be amendments to the Employment Services Act. And in fact, we are waiting for regulations to be formalized for our sector. We've been waiting for, well, going on nearly 10 years since the introduction of the Employment Services Act. And the current holdup is actually the National Labour Migration Policy. So regulations for our sector have been drafted and engaged and consulted on quite a lot of detail over several years. I'm a member of the bilateral task team representing Capes. We meet every second month with the Department of Labour to address these and other issues. And so we've been waiting on these, but there is a belief that until everything can be done, and I guess that makes sense, we don't want to have to amend legislation multiple times, given the process and timelines that have to be followed to do that compliantly. Until we get the National Labour Migration Policy resolved or concluded, we're not going to see the regulations for our sector come into play. So what are these changes? So the changes are, it is codifying that for any employer, so that's regardless of whether you're in a particular sector or not, you may only employ foreign nationals who are entitled to work in regards to Immigration Act or Refugees Act. Now, of course, that has always been the case, but I think it's just really reaffirming that. It also now reinforces the importance that the obligation rests with the employer to ascertain that that foreign national is entitled to work, and that they're entitled to work in that specific position for which they're being considered, and that it is an alternative that is only considered once there is an exhaustion of the opportunities to employ South Africans with those skills. It also then goes further to say, well, if you're going to employ a foreign national, there needs to be a formalized skills transfer plan, which is put in place so that those skills can be transferred for the duration of the employment contract period, the visa period, so that they can equip a South African person to be able to take on that job, hopefully, when that contract concludes. Now, of course, that's very simplistic because it's not necessarily just about learning on the job. Certain skills and qualifications, of course, require time and process. It's also to ensure that foreign nationals are employed at the same terms as local workers, and then the obligation to retain all necessary documentation. Now, within the amendment bill is the proposal that the minister would set quotas regarding the employment of foreign nationals in particular sectors of the economy or in particular occupational categories. And I think, to John's point, interesting, in the 2022 transformation numbers, we saw across the board in all occupation levels except skilled, which was quite interesting to me, about an average of 3% foreign national representation. The highest level at 3.5% was in fact an unskilled, and you can see why that would be perceived as seriously problematic. How are we employing foreign nationals in unskilled roles within our businesses when we have so many unemployed South Africans who should, regardless of their level of qualification or experience, be able to fulfill an unskilled job? Interesting for me was that the lowest percentage at 1.7% was in fact at the skilled level, which is where we see, of course, artisans and others with those skills that we typically would assume to be in short supply and high demand, and where we would presumably be implying foreign nationals. So the minister, of course, would have to consult with the Employment Services Board and take into account public consultation in order to effect any quotas. Where are we in the process? So this has been a very frustrating and delayed process. As you can see, this is the timeline that was in fact released by the department. We are almost a year behind schedule, as you can see. There was a public consultation process which took place last year, and CAPES, which is the lobbying and advocacy body to which the TSD belongs, prepared a very detailed response to the National Labour Migration Policy, obviously on the broader context around skills and accessibility of skills, but also focused on the impacts to our industry as a whole. More than 600 written submissions were received, and they have been considered by the department. I spoke yesterday to our representative, Bev Jack, who confirmed that it's waiting to go to NEDLAC. It has been in that kind of status for some months now. It is touted to be in the February, March. Of course, February is now gone and we're looking at March. But she will, of course, keep us updated. I suspect with the 30th of June looming large, that there's going to be a renewed focus on trying to get this to the next stage. So we will, of course, keep everybody informed, and the TSD will onwards inform you. I think at this stage, it's really important just to make sure that we're all on the same page when we reference a foreign national. So the definition of a foreign national differs depending on whether we're talking about employment equity reporting or whether we're talking about immigration. So a foreign national is an individual who is not a South African citizen or who does not have permanent residence issued in terms of the Immigration Act, or who has not been granted recognition as a refugee in terms of the Refugees Act. So that is a foreign national we're talking about today in the context of national labor migration policy. Of course, for those of you who also do employment equity reporting, you will be aware that a permanent resident, although they are in possession of a South African ID, would be classed as a foreign national for employment equity reporting. So those are not necessarily going to be exact correlation in terms of numbers when you're looking at doing your due diligence. So very important to differentiate between the two. So in essence, we're talking about an individual who is in possession of an ID, and that could be a refugee and or a permanent resident. They would be exempt from the national labor migration policy restrictions because they do not require a visa to work in South Africa. By virtue of their refugee status or their permanent resident status, they are free to move within the labor market as they please, same as any South African. A foreign national, for the purpose of the National Labor Migration Act, is somebody who is either documented or undocumented. So let's look at documented. So what do we mean by documented? So this is a person who is in possession of passport and has a permit or a visa which has been given to them through the government and the various processes. So typically in our world, that would be somebody who has a work visa, which has a limited time duration and typically is linked to some level of skills shortage. So a critical skills visa on the one hand, which is of course linked to those roles or occupations which are on the critical skills list, most recently updated in February and then again in August 2022. An individual may have a general work permit, but again, there is a process that needs to be followed that says we will grant that permit if the organization can show us that they were unable to secure skills in that particular role from a South African base. Then we have exemption permits, and these are very specific structures or frameworks that were set up. And in particular, we're going to focus today on the Zimbabwean exemption permit because that is the one that is imminently coming to an end. There is also, by the way, a Lesotho exemption permit in place, but those permits currently are running until June 2024. But presumably, they will follow a similar path to the Zimbabwean exemption permit when their lifetime expires. So the Zimbabwean exemption permit expired back in 2021, the end of the year, and after much frustration being exhibited, particularly from Zimbabweans, who many of whom have been living in this country for a decade or more, and who have jobs and families and homes and children in school, there was a concession made by the government not to extend the visa. So the permits have expired, but to enable a 12-month period under which those individuals were intended to either apply for another kind of right to live and work here, or to wind up their affairs and go back to Zimbabwe. There continues to be concern around that process, and I'll talk a little bit more about the pending legal action in a moment. And there has been or was a further extension to June 2023. Many ask me, do we think we're going to see another exemption or extension? And I can't say. Even in talking to those who are serving, there's difficulty in making an assessment. I think there is the practicalities around the extended timelines that processing is happening at the Department of Home Affairs, which could potentially push out an extension. I think the outcome of the pending legal action, which is due to be in court in mid-April, may also have an influence about that decision. But one has to assume that given the current state of the economy in the run-up to a national election, we've got to assume that it won't be extended, and we need to then prepare accordingly. And then, of course, we have undocumented foreign nationals, and these, of course, are a number It's an amorphous number. We don't know how many people there are that have this status. And of course, these are individuals who, if they are in your employ, you are immediately in contravention of the Immigration Act. And so you would have the liability as the employer, because, by the way, there is no crime in accepting a job if you do not have a permit. You would be deported potentially, or hopefully, as an individual who has contravened the right to be in the country. But the liability and the obligation sits with the employer. And so it's absolutely critical that you do a check. Now, I'm going to go quite quickly through these sections, but I've given detailed slides, as there may be some of you who have employees in these categories and where you may be interested in getting more detail. Now, this is information and an explanation which has been provided by the Department of Home Affairs. So this is the view of our government, who of course is managing this. So an asylum seeker is a person who has fled their country of origin and seeks recognition and protection as a refugee. Now, this is a person who is not yet granted refugee status, but they are recognized as having come into the country under those conditions. Now, there's a process that needs to follow, which I'll briefly run through now, during which time their asylum application needs to be considered and a decision taken as to whether or not this is an individual who meets the criteria to be considered a refugee and therefore given that protection within our country. Alternatively, if they are not, then they must leave the country voluntarily or be deported through the processes. A refugee is someone who has been granted asylum status and protection in terms of the Refugee Act. And this is our alignment as a country to the 1951 United Nations Convention. And so there are there's specific reasons why somebody would be considered a refugee. So it could be what they refer to as a convention refugee, which is somebody who has a well-founded fear of being persecuted due to their race, religion, political opinion, nationality, etc. And then we've got a person who is in need of protection because they would be, if they remained in their country of origin, subject to danger of torture, risk to life, or some kind of unusual, cruel treatment or punishment. Now, nowhere in the Refugees Act is there reference to an economic refugee. And I think we're seeing, I just was watching this morning on Sky News, we know that the Prime Minister Rishi's got some quite bold ideas on what he's going to do with what they refer to as the boat people. But we see, of course, economic refugees becoming a very real migration challenge for many countries around the world. So this is a process that describes how this refugee and asylum seeker process should go. Now, it's important to understand that asylum seekers are given some documentation, so they are documented, even as they may be waiting to be assessed. And we have many because there are huge backlogs in our system, and particularly compounded during the COVID times. But it is important to recognize that an asylum seeker does not automatically have the right to work in South Africa. So it's very important that if you do have somebody who presents as an asylum seeker, is to check their asylum seeker documentation, one, to see that it's still relevant and valid, because they are only valid for 6 months at a time. So they have to be renewed. Ideally, it shouldn't be for too long before they are formally assessed and either granted refugee status, which includes the right to work, unrestricted, or deported, escorted, asked to leave. But because of the delays, we have seen an increasing trend towards asylum seekers being granted right to work or study. And I guess that is our government's attempt to say, well, if these are individuals who are going to be in our country for a period of time, whilst we assess their refugee claim or application, rather they are able to look after themselves financially by accessing work. So please just do check that. I think at the moment, of course, our asylum process is under the spotlight. As some of you may be aware in the news, the issue of the 22 Afghan refugees, and which calls into question perhaps that South Africa's asylum-seeking process is perhaps a little, dare I say, soft, considered compared to other countries. And so we're subject to a range of litigation presently to try and see where are the rights and how do we make sure that we don't unnecessarily restrict access, but that we do also protect ourselves as a country from potentially having individuals who are not genuine in their application coming across our borders. So let's switch now to our focus on the Zimbabwean exemption permit. And again, I've given you a lot of detail here, but just in the high level summary, as we know, in the early 2000s, we had a mass influx of Zimbabweans coming across our border, given the political situation in Zimbabwe. So there was a lot of political challenge and upheaval, and of course, resulting prosecution or persecution potentially of those who were not supportive of the prevailing government at the time. We also know that there were economic pressures, of course, which came from that. And so we had an influx of Zimbabweans coming into South Africa, to the point that our country's asylum processes were unable to manage it effectively. And given that we were attempting to regulate as best possible the individuals who were coming in, the government made a decision to create an exemption permit. Now, by the word exemption, it means that it did not follow the standard processes. And originally, it was the Zimbabwean special permit, which allowed Zimbabweans who applied, so they still had to apply and they still had to provide, for example, a clearance, a police clearance, which showed that they did not have any criminal record, etc., to be able to be regularized into South Africa. Because without that, they found it exceptionally difficult, even just to function. You can't open a bank account. You know, obviously finding work, potentially there may be some illegal channels under the table work, but it was, how do you actually function? How do you get your children into school? How do you have a bank account? How do you, rent a property or buy a property? And so the ZSP was created. And it was originally for a period of 4 years. It was then extended or altered, let's rather say that, to become the Zimbabwean exemption permit, which came into effect on the 1st of January 2018. And it was always intended to only be for 4 years. Now, there are many conditions attached to the ZEP. They cannot be renewed, so you can't just go and renew it. And in fact, there is going to be no more ZEP, which is how we got to the point where at the end of December 2021, we now have a situation where anybody who was under that, and there are about 180,000 Zimbabweans who are registered with the ZEP, who are impacted. Now, a ZEP originally had the conditions that said, if I want to apply for a work permit, as an example, I would have to leave South Africa, go across back home to Zimbabwe and reapply. And that presents some challenges, I think, for many, not least of which, if I have the means by which to return to Zim, is that some of the documentation and processes that would need to be concluded within Zimbabwe may be challenged by the current economic situation or dysfunctions within certain government organizations. What is interesting is that under the extension, those conditions have been relaxed, which means that an individual who is in South Africa on a ZEP can in fact apply for a different visa or different right to live or work whilst based in South Africa. So that is one of the gives that our government had to try and make it easier. Now, as we know, this has been extended to June 2023. There is currently a legal challenge which is being put forward by the Helen Suzman Foundation. And what's interesting is they are not arguing that the Department of Home Affairs Minister was illegal in his act, because there is it's a special exemption permit. It was very clear from the beginning that it would only be for 4 years, and it came to an end. What is being challenged by the Helen Suzman Foundation is the fact that the argument is that the ZEP was created as a result of government's incapacity to address or properly deal with individuals who came across the border who potentially would have been at the time eligible to be considered asylum seekers and then refugees. And had they been addressed at that point in time, those are individuals who would have received refugee status, which, as we know, would grant them access to live and work freely in South Africa unrestricted, providing, of course, they do not become undesirable citizens by committing any crimes or other undesirable acts. And the reality is that today, specifically for those that are here 10 years later, if they were to apply for asylum seeker status now, they would not meet the definitions. And that is the argument in a nutshell that the Helen Suzman Foundation has, is that government has created a difficulty now because they made it easier for themselves at the time and created challenges. I think what we see too, which is interesting, so the date has been set for between the 11th and 14th of April. I suspect that this will be a fairly high profile case and we will get updates in the news. But what is interesting is that Operation Dudula and then the All Truck Drivers Forum in Allied South Africa, as we know, truck drivers in particular have been targeted physically, of course, as a group of so-called foreign nationals. And these two organizations tried to join in to these proceedings, and they wanted to get on the bandwagon to try and drive their agenda, which is to say that the proliferation of crime in our country is a direct result of having all these foreign nationals. Now, neither of them was successful in being adjoined to the proceedings. And on the basis that they are found to have greatly exaggerated the claims of the number of migrants living here. So interesting, the Institute for Security Studies most recently says that about 6.5% of South Africa's population are foreign nationals, some of whom will be documented, some of whom will be undocumented, of course. But this is in line with international population trends. So we don't have a disproportionate problem in South Africa. What is interesting is when they explored this notion that foreigners are the bulk of our criminal element, is that the Minister of Justice, Ronald Lamola, said that when they looked at the 2021 statistics of our prison population, which sits at about 135,000, only 3,500 were foreign nationals. So just 2.6% of our population, of the prison population were foreign nationals, as opposed to 6.5% of our population. And so they really were disproportionately less prisoners from amongst our foreign national component. And of course, now we will wait to see what is going to happen in regards to this legal challenge. And I think that will have a distinct impact on whether we see any form of extension to the current deadline of the 30th of June. I just wanted to point out quickly that the ZSP and its successor, the ZEP, were very specific in their conditions. So they said that a permit holder could conduct work or employment freely, which we know, but it expressly excluded the individual from applying for permanent residence off the back of the time that they'd spent in South Africa. So this is not an option for anybody who is on a ZEP. So regardless of whether they've been here for 10 years, they would not be able to count those years towards a permanent residence. So what they would have to do, if that was their end goal, would be to apply for some form of work permit or another permit, perhaps a spousal permit if they are married to a South African, to regularize, too big of a word for this morning, regulate, let's say, their right to live and work in South Africa. And then from there, the time could start counting arguably towards a concession or consideration for permanent residence. Okay. If we have a look at the an update from Expat Web, which is a work permit and expatriate business in South Africa, and one that we do work with when helping our clients to manage this. You can see that there are some conditions. So what is important to recognize is this grace period. So it's not an extension of the permit per se, but a grace period means that individuals who had a ZEP and who remain in the country beyond the 31st of December 2021, its expiry, may not be arrested, ordered to depart the country, detained or deported if they have a valid exemption certificate in their passport. They also may not be treated as a prohibited person, undesirable person, or illegal foreigner in terms of the Immigration Act. And that means that banks can't close their bank accounts. They can't foreclose on any debt that they have. They are still entitled to be treated in the same way that they would be treated if that permit was still valid. Now, what is the benefit for them? If they were a ZEP holder and they really are running out of time now, so if you do have these individuals in your workforce, I really strongly urge you to give them some guidance. They need to make an application, and they need to do it fast. They are fast running out of time. And if they want to have the benefit of making that application from within the country, they need to be able to do it during this extension window. Because once that window is gone, they will have to leave the country with all the costs that that comes with, and make an application from outside of the country. So let's move on now to talking about critical skills. So here it's not just our ZEPs. The critical skills environment is also plagued with changes that are making it more difficult, even for individuals who currently have a critical skills visa. So in the first instance, we cannot assume that someone who has a critical skills visa now is going to automatically be considered for renewal. So some occupations that were on the critical skills list are no longer on the list, which means they are entitled to be here for the remainder of their visa period. But once that visa period expires, they would have to leave. Even roles or occupations which have remained on the list, there have been many changes to the requirements, and particularly in regards to qualification level and membership of professional organizations. And so it's possible that you could have someone who qualified for a critical skills visa previously, but based on the changes, does not qualify going forward. And I thought to share a case study which came across my desk towards the end of last year, which is highly frustrating to me as someone who kind of hopes for the big picture being considered. So in this particular instance, it is an architect. It's an architectural firm, and an individual who is of Congolese origin acquired a study visa legitimately some 10 years ago. Came into the country to study architecture, completed her degree, and I think her honors degree, and was then employed by this business to conduct her sort of practical work experience, which she did. And that was all done according to work study visas and everything else. Subsequently, they applied for a critical skills visa for her. It was granted, and she has worked in accordance with the conditions of that visa. I think it's been renewed. I stand corrected, but I think it was renewed once previously, and it came up for renewal in, I think it was about June of last year. She made attempts to apply for a renewal on her critical skills visa, and there were all kinds of hurdles that were created in the process, not necessarily of her doing, but changes and the waiting for the critical skills list to be updated, etc., etc. Anyway, long story short, she is then sitting in a position where she is no longer legal to be working, and she makes the decision to go back to the Congo and to apply again. Now, the reason she was turned down for her critical skills visa this time is because the benchmark for qualification had moved up to a master's level, and she only had an honors. There was some discussion around, could she work and do her master's at the same time, given the pressures of both study and her job. And it was determined that that was going to be the course of action. And so she was leaving to go back to the Congo to make an application from her country of origin, as is required, for a study permit to complete her master's, with the goal ultimately of securing a critical skills visa and potentially permanent residency. She is well established in South Africa, is a property owner, senior person within the business who also mentors trainees and graduates. When she exited at OR Tambo, going home, they looked at her visa and saw that she had stayed in the country 6 months longer than the visa, and she was promptly declared undesirable by the officials at the border. And what that means essentially is she will not be able to come back. She won't even be allowed to come back into the country as a tourist for the next 5 years. I stand corrected, but I think it's 5 years. And any attempt to try and secure a study visa is going to be scuppered by that undesirable status. And so it is a tale of caution for any foreign national who potentially has stayed longer, even if it's only a small period of time. It seems that at an official level at the border, its undesirable status is being thrown about. And that has some significant issues. She has sought, as far as I understand, legal action, and they will attempt to appeal that, given that there were extenuating circumstances in this regard. Now, what's so frustrating is this is a person who is highly skilled, who works, and I think it's important for context, works in a small Black business. What's interesting is the work she does is also specialist in that she speaks French, of course, coming from Congo, and this business has secured an entire division of work that they're performing for Congolese clients. But the Department of Employment and Labor, in assessing the skills availability within South Africa, chose to declare the language and the understanding of the market as irrelevant, and that a South African would be able to do that job. And that's the reason why her visa was turned down, because she couldn't apply for critical skills. They then applied for a general work permit, and it was turned down. So unfortunately, we are dealing, it appears, with a rather reluctant processing environment, where even things like genuine language, knowledge of a specific market, and being already in a sector that has a skill shortage does not seem to be taken into account necessarily. All right, and interesting stats from another provider. This is BAL Global Practice. They also are a visa and immigration business. And they published this towards the end of last year, showing that they've seen, just in the last 2 weeks, which was towards the end of the year, a 70 to 80% increase in rejections for visa applications. And for them, notably, there was a high number of inter-company transfer work permits which were being rejected. And I think this kind of feeds into my own experiences. I, of course, don't make applications, but you'll see that as an industry, we work with the department. We're also trying to pilot a model to try and manage this a bit more effectively. And there definitely does seem to be a fairly strong belief that work permits should be very few and far between. Right, if we have a critical skills list, the August list was updated, included an additional 39 roles. And I've highlighted a couple which I made assumptions would be those within your space. So architect back on the list, it wasn't on the list, but as my example just shows, they've increased the requirement from a qualifications and experience level. We have civil engineers, mechanical engineers, industrial engineers, metallurgists, quantity surveyors, and geologists, which have now been added back. On the other list, we do have things like refrigeration technicians, certain mechanics, and other trades as well, which are recognized to be in high demand and short supply. Again, I'm not going to spend too much time. You can reference the slides if this is of specific interest, but there have been changes to the critical skills process. And very important is that under the new critical skills list, applicants must be in possession of an offer of employment. So previously, if I was a member of society who has a critical skill, I could apply for the list, come into the country, and then seek opportunity. Now there is a requirement for there to be an offer of employment on the table when a critical skills work visa is being considered. The Department of Employment and Labour must verify that this is an employer who is in good standing with the department, and they would then obviously make the recommendation to the Department of Home Affairs, who would then have the power to grant the full 5-year period of the work visa. Importantly, there has to be a lot of documentation submitted, including a document which confirms that the individual's qualification is recognized by SAQA, given that these are individuals who would have studied, of course, elsewhere, and they should have some 5 years of post-qualification experience. They would have to submit some testimonials from previous employers. And this is also a departure from where we were before, where many individuals who might have come into the country under study permits were studying in fields that formed part of the critical skills list, who could exit directly from studies, secure a critical skills visa as a graduate, and access employment. So this is really a big departure, and one which is going to create, I think, some additional complexity for those who are hoping to secure or renew. So an individual application, the critical skills list, and we've just given you an indication of the process, but although it's an individual application, we now see the requirement to have an offer of employment as part and parcel of the application process. General work permits and intra-company permits, of course, are linked to an individual company who would make the application directly. I'm not going to spend too much time on intra-company. This is very often for multinationals who may be moving skills from one country to another. And as you saw in that previous slide, even these are receiving a far higher level of rejection than previously. That's concerning, I think, for me, given that we want to attract foreign direct investment. We want to have multinationals in our country, particularly if they are of an industrial nature and where there will be high levels of employment. So that is rather concerning. And then we have the general work permit, which is one which is not linked to a critical skill. But what has to happen is you have to, as an employer, be able to show that you have done everything in your power to find a South African employee. Once you've got to that point, the Department of Employment and Labour is then required to do a search themselves, and they will send you who they believe is suitable, and you would have to go through a process of assessing those individuals, and if you are rejecting them, to be very clear around why you're rejecting them. There's also, and I'll show you the scarce skills model pilot from a CAPES perspective, the department doesn't only look in their database, they now reach out to the staffing industry to find out whether there is an availability of skill. And then if and only then the department is comfortable, so the Department of Employment and Labour is comfortable that there is not a local skill available, they would then issue the recommendation to the Department of Home Affairs, who in turn would make the conclude the visa process and issue the visa. This is just a quick model to try and show you the pilot. So this is happening informally at the moment. Informally at the moment, but we are trying to formalize this. So the goal here is twofold. So one is we would like to assist business in ensuring that there is a robust process that ideally identifies scarcity correctly. What has happened in the past is a local Department of Labour will phone a local recruitment business who may not even be in that sector and ask them, do you have any candidates of this kind? And they may say no. And depending on the official, they will say, okay, no candidates are available, when in fact there may well be South Africans available. And it is very important for us as a country to put South Africans first. We do need to do that. Conversely, we have a situation where potentially an agency is contacted who sees this as an opportunity to make a placement and says, yes, I can find those people, when in fact, perhaps they can't. And a visa is then unnecessarily stopped when there is not a real consideration about availability. And as we know, availability, so simply saying we have people with these skills doesn't mean that they are willing to move. And in particular, very often critical skills visas are applied in environments which are less than desirable. So outlying areas, I'm talking to you today from the middle of nowhere at a mining client. There's no cell phone signal, there's hardly any roads, there's not much here at all. And so somebody who has a high level of skill and who has lots of opportunity is potentially going to choose to work somewhere closer to civilization, dare I say. So this is just an example of the process. Now, it does, of course, provide opportunity for our industry players too, because if they do have access to those skills, they would then be able to engage in the facilitation of that placement at a fee, of course. So this is an area that we are working on and continue to try and tighten up, and certainly we'll keep you posted. I just also want to touch very briefly, and again, there's quite detailed slides available. I want to get through the material so that we can take questions. Just because you're married to a South African in South Africa does not mean you have the right to work. And that is as a result, I believe, because we have seen an abuse of that system. We've probably all heard the story of somebody who tries to get married only to be told they are in fact married already to some random person they've never met before due to some kind of corruption happening on the back end. So if I come into the country as a life partner, so I don't even necessarily have to be formally married, there are conditions attached, and it can, of course, extend just as much to heterosexual and homosexual partnerships, same-sex partnerships. I have the opportunity to come in as a relative. If I come in as a relative, I do not have the right to work. So I'm coming in to be taken care of by my partner. If I come in on what is known as an extended visitor's visa, which is issued for up to 3 years, I can apply for endorsement to work. So it's not automatic. I can apply for endorsement or authorization to conduct business or to work or to study. Now, again, I would need to be in possession of an offer of employment to have that granted. Study visas too have a limited opportunity for working. So individuals who are on a study visa may not work full-time, and they may not work for more than 20 hours in a week. There are also some conditions around holiday periods. They can't work full-time in the holidays, or they need to link their work to, if it is holiday or work related, so like somebody's at a Institute of Technology where they've got to do a 6-month practical for somebody in a technical field or perhaps an apprenticeship, those may be exempted for longer periods because they're linked to the acquisition of skill. Now, again, I'm not an immigration specialist, so if you're looking for advice or you have employees looking for advice, I strongly recommend engaging with an immigration specialist. There are many very reputable ones in the market. If you're interested, we can also refer you. Okay, so there are various things in the legislation which includes what we call a waiver, and that is where a company or an individual may make a representation to the Department of Home Affairs to have certain conditions waived or certain requirements waived. Now, this is a pretty complex process, and there are many different reasons why something might be waived. So, for example, the provision of a specific document, which I may not be able to get because I don't have it, I've fled, I don't have it, the institution in my country of origin is unable to locate it or to provide it, or there's some kind of unrealistic delay, then a waiver may be granted. But they are considered on a case-by-case basis. In essence, the current extension on the ZEP is a form of waiver. And what it's waivering is it's waivering the requirement for the Zimbabwean to return to Zimbabwe to make application. And so that is why it's critical that these are done now. I just wanted to touch on, again, and this is from within the National Labour Migration Policy, we hear about the discussions of a quota system potentially, but the department themselves have highlighted certain sectors as being those where they believe there is a higher than normal number of foreign nationals, and where potentially there are abuses or exploitation taking place, and construction and related services are top of that list. Mining and subcontracting too are recognized. We know that the mining industry has a high number of migrant workers and has done traditionally. But we also see domestic work, farming, hospitality, and I think most of us are very cognizant that very often we're sitting in a coffee shop or a restaurant and we are served by a foreign national. So those are definitely areas which are focused. Now, I don't know this for sure, but if I was the department and I was figuring out where to go and look, I would be starting with the TES claims. So UIF TES, so COVID-19 TES, applications required us to give a list of all our employees. And of course, we had to specify ID numbers or passport numbers. We also had to treat foreign nationals very differently. We had to load them onto the U-filing system, given that the UIF system does not accommodate anything other than a 13-digit ID number. And that would be a very good place to start. So again, I'm not sure that they're going to do that. But if I was DEL, Department of Employment and Labour, I would be pulling that information from the UIF and using it as a starting point to decide which employers to go and have a chat to if there is a high number of foreign workers. What is interesting to me is if we have a look at the statistics. So if we look from 2021 data, which of course references 2020, and then the 2022, this is from the Department of Employment and Labour's Employment Equity Commission report, we can actually see that there have been some movements. This is the percentage of foreign nationals reported by sector. And to 2021 to 2022, there has been a shift in the construction environment. So we have seen an uptick in the number of foreign nationals, both permanent and temporary, in that period. Now, of course, that uptick is not necessarily only limited to foreign nationals. I think it would be an uptick in employment in general, given that this would have been a down period and we're moving in. But when we have a look at 2022, there is an increase in the number of permanent employees, but a decrease in the number of temps. In the mining sector, as we know, this has a high degree of foreign national employment and always has done. But interestingly, that has diminished. So we've actually seen it go backwards in regards to the mining sector. Hospitality, also looking at a number which went down in the 21 period, but has an uptick, particularly in the temp period in 2022, which makes sense given that we went through the horrid COVID period, which disproportionately negatively affected the hospitality sector, and where ideally there's an upswing and a change in the nature of employment. I think many businesses have, of course, realized the importance of having flexibility to up and down scale, and again, presents opportunity for our industry. What's interesting is if we look at agriculture. So agriculture continues to grow in the number of foreign nationals who are employed. And I think in this particular sector, there is a big belief that foreign nationals are being employed because they are willing to work for slave wages, some of the rhetoric that has been bandied about. And that is not that South Africans don't want to do the work, they're just not prepared to do the work for unfair wages. Now, whether that's true or not, isolated or not, I cannot say. But we certainly do see a high disproportion of employees in that sector. I just popped in transportation and storage only as out of interest, because we can't obviously within that separate out the drivers, but the trucking industry is perceived to be unduly represented by foreign nationals. And yet, if we look at the numbers, it's actually amongst the lowest representation of foreign workers within the stats. Okay. Now, what does this mean for us as employers? Now, it's very important to understand that our legislation does not differentiate between a South African or a foreign national. All legal obligations, all legal rights are extended to foreign nationals, including those who are not in possession of a valid work visa. So because someone's visa has expired, or perhaps even an undocumented person, they are still afforded legal protection, including from unfair dismissal. And so if we discover that somebody in our workforce is not legally entitled to work, we are not able to keep them because we would be in contravention of the Immigration Act. But we simply cannot just say to them, thanks, you don't have a work permit, goodbye. We have to ensure that we follow correct protocols so that those individuals are afforded their rights under legislation. They have recourse to the CCMA. Of course, they could not be reinstated by the CCMA in the event that the unfair dismissal accusation is upheld. But, of course, the CCMA could still make a recommendation or a finding for compensation. So it's very, very important that we follow a due diligence process and ensure that we do the right thing to protect ourselves as a business from the Immigration Act and its potential fines that come with that, as well as, of course, from a labor law perspective. So if we turn our attention to the Immigration Act, what does it require us to do? Well, it requires us to ensure that we only employ foreign nationals who are entitled to work in our business. So we must make sure that they have a valid passport or ID and that their visa is valid. We also have to make sure that they are being employed consistently with the conditions of the visa. So in the case of a study visa, no more than 20 hours a week. But did you know that if someone has a visa, a critical skills visa that says they have a visa to be a IT programmer, I can only employ them as an IT programmer if I promote them to a project manager, an IT manager, or any other role. They are now in contravention of their visa. And so I cannot employ them in that condition. And I think that's an area where there are definitely potential risks for many employers who would have brought people in legitimately, but whose roles have evolved or changed to meet operational requirements, and which now would put them in a position where they are non-compliant. We're also required as employers to tell the Home Affairs when someone leaves our employment. And we are to keep, obviously, all documentation once they've left for at least 2 years. Of course, good practice from an employment perspective is to keep 3 years worth of employee documentation. How can we verify authenticity? Well, this is where it becomes difficult. So those who are in possession of asylum seeker permits, which is quite common, would have to be verified with a refugee reception center. On the asylum seeker certificate, it should tell you which center authorized it or issued it, and you should use that detail to assess. You can also verify by contacting missions@dha.gov.za, calling the verifications department so that you can verify the documentation. I'd like to just stop for a moment and play a little clip from the news, which talks to the current focus from the Department of Home Affairs following the recognition that there is a high level, unfortunately, of fraudulent action happening within the Department of Home Affairs itself.
Home Affairs Minister Dr. Aaron Motsoaledi joins us now for a discussion and to just also bring us up to speed with some of the more pertinent findings of this report. Minister, good to see you. Welcome to Morning Live.
Good morning, Sakina. Good morning to the viewers and listeners out there.
Minister,
thank you very much for having me.
Thanks so much for speaking to us this morning, because I must say, just listening to your presentation and listening to Dr. Cassius Lubisi yesterday in Parliament, it was absolutely flabbergasting and hair-raising, some of the findings that came out. A 25-year-old looking to retire, they say South Africa is the place to come because we have in South Africa had those sort of permits being issued to foreigners. You can retire at 25. So without getting ahead of myself, Minister, perhaps I should afford you the opportunity just to give an overview of some of the findings into these anomalies.
Thank you, Sakina. Well, it will become necessary for me to outline why I put up the committee. Then you'll understand the anomalies that were found. Sometimes in 2020, after Reverend Bushiri escaped South Africa, we discovered in the Department of Home Affairs that the things for which the Hawks were looking for I mean, you are aware that he was arrested by the Hawks. He was able to do those things because he was a permanent resident of South Africa. In other words, he had a permanent residence permit. And we found that it was acquired very irregularly in a fraudulent manner, him and his family. I then learned immediately thereafter from some officials that in Omotoso, the Reverend Omotoso, who is being charged for rape in the Eastern Cape, it looks like it's a similar thing. While I was still mulling over this, we received a petition. We have just hired an advocate who's the head of our anti-corruption unit, and she hit the ground running. She was arresting, investigating, suspending people. We then received a petition from 14 people working in the permitting section. That's where they give all those documents you have mentioned, Sakina. They wrote a petition and said, can the anti-corruption unit please stop investigating our errors? Please stop, don't investigate us. We are committing errors, but don't do anything. This was a shocking revelation or a shocking statement. My question was, if it is true there are errors, to what extent are we running South Africa Department of Home Affairs permitting system in an erroneous way? Does it mean there are people here who are naturalized citizens erroneously? There are people who are running huge businesses, having corporate visas erroneously, study visas, and you know, it was quite scary. But the second thing was, what if these are not errors? And it so happened that with the findings of this committee, they happen not to be. So I said, no, let me put up this committee of very prominent people, some of whom are investigators in the former Scorpions, SIU, in the present Zondo Commission. That's the type of team I put up. Others are in the legal profession. As you know, Cassius Luvisi was a long-term civil servant. So I put them together. And indeed, they found that these are not errors. These are systematic corruption practices that are happening in the permitting section.
Rather sad, but I guess unsurprising. The number that was touted at this time associated with this report was that 45,000 permits were found to have been erroneously or fraudulently put out there. There is heightened focus and attention. We are seeing increased inspections, and particularly within hospitality, manufacturing, construction, agriculture, and of course, ministry and retail. And there has largely been a negative response from the Department of Employment and Labour with regard to permit applications, including those that are renewals. So there is a very real need to conduct a due diligence internally to ensure that you're not found to be in contravention. Now, this warning has been issued by multiple stakeholders. I think the biggest challenge for employers is, how do I know whether the documentation I've received is legitimate or not? Now, that's really difficult. I think as an employer, due diligence requires us to pay attention, to do our best as far as we can, exercise reasonable caution to assess whether or not this is legitimate. I have a case at the moment which has been referred to me. We have referred it into the Department of Home Affairs, where an individual is in possession of a general work permit. And he, when questioned around it, he admitted that he had bought it. Sadly, he bought it from an official who did him a favor by working on a Saturday outside of the embassy. So there are many that are out there, some of which are still being issued. So the importance is, do your due diligence, do the best you can. I've popped on the right-hand side here some of the sort of flags that you might want to look out for. Unfortunately, there are some genuine documentation floating around which has not necessarily been issued correctly. Now, assessing whether that individual is on the VFS system is probably one of the best ways. So has that piece of paper been issued outside the gates? And in which case, if it hasn't been bought, it's unlikely that that person is going to appear on the immigration database. So if there was a check done by yourself, you wouldn't be able to see that. Now, we don't all have the ability. I'm not 100% sure whether someone like MIE or some of the credit bureaus that we use would be able to offer that service. I do know that many of the immigration specialists can. So if there are any that you are concerned about, it would be a good idea to have that checked. Now, it is absolutely critical that you do that due diligence on all foreign nationals. So anybody who is, well, in fact, I think it's good due diligence on all employees. One of the things that did come up also, as some of you might know, I represented business on the issue of TES, and I mean, that's got still hangovers deluxe. But one of the things that came up a lot, and a lot more frequently than we'd had hoped to have seen, is the fraudulent use of ID numbers. So where an ID was flagged on multiple employers, and when investigated, it were different names attached to those ID numbers, individuals who were in possession of fraudulent ID documents. So I think due diligence in general around your workforce, but with a particular attention to those who are not South Africans, is to assess whether they have documentation, number one. What are the conditions of that documentation, and are we compliant in terms of the role that the person is performing? Are they valid? When are they going to expire? Putting a flag in place. And again, I've got a spreadsheet, a simple tracking spreadsheet I'm happy to share with you as part of this webinar, which you may find useful. And then, of course, obviously our ZEPs. Again, I've given you a summary of the various current sort of visas and what their limitations are. But for this last section, I like to focus on the practicality aspect and really, what do we need to do? So as an organization, we need to conduct due diligence. We need to make sure that we know who is in amongst our mix. Now, obviously, we've got South Africans, and hopefully they all are in possession of legitimate IDs. We've got those foreign nationals who have a right to remain. So permanent residents, refugees, we're still, of course, going to report them from Department of Employment and Labour for EE purposes as foreign nationals, but they are not included within this bunch. We still need to have their documentation, but they are unaffected. We then have those who are on work permits, and they could be a general work permit, a critical skills, or an intra-company. Our exemption permit holders are ZEPs, so Zimbabwean exemption permits, and Lesotho exemption permits. And by the way, it must be in their passport. So just because I'm a Zimbabwean in South Africa doesn't mean I am under the ZEP. I have to have been given the ZEP to be given this grace. If I'm here undocumented, then I'm irregular and illegal, and there's all kinds of additional risk attached to that. If I came on a work permit or something else, then I've obviously got different conditions. So what we need to look at is obviously how many individuals are impacted. What roles are they in? What are their current employment status or contract type? And that's really important from an operational requirements and planning perspective. What we've seen in some clients, and I've got one particular client, all of their team leaders within their production area are all ZEPs, and unfortunately are also not likely to be able to easily get work visas in South Africa, and that's going to leave a really big hole in their operations in terms of institutional knowledge, skill, etc. Do we have the documents? Because we should have the documents. If the Department of Labour turns up, we need to be able to provide the documents. Are they valid? Are we employing people compliant with the conditions of those visas? When do they expire? So we can keep a track on that. What is the possibility of renewal or change? And again, I appreciate that's a bit of an assumption, but having a look at what the skill set of the person is, what the qualifications are, how easily could I replace this foreign national with a South African is going to give you an indication on whether or not there is a likelihood that they will be able to extend their stay. And then that gets us into the impact situation. If these people all left, what is the impact on my business? What kind of scenarios are available to me? What options are there? And so we look from an operational perspective, of course, the scope and number of people we're talking about, which areas of our business are impacted, and what might be the bottom line impact if these individuals were to exit. I think specifically, if we then focus on skills, what is the nature of the skills loss? How easily might we be able to replace them, and at what time and cost? So that we can start working towards that now. And do we have any possibilities within our ranks for succession from amongst our South African workforce? And of course, we also can't ignore the people component. So there's institutional memory and experience, which potentially creates a leadership vacuum. But there's also the relational value, which needs to be considered. And I think this is an area where, as business leaders or as HR professionals, we need to pay particular focus on. We have typically two schools of thought. We have those South Africans who are in strong favor of the exit of foreign nationals to make space for South Africans, and who would be happy, presumably, and maybe that's not quite the right adjective, but happy to see the exit of foreign nationals from amongst their colleagues. There are others, of course, who are going to be looking at the individual and saying, well, what did Natalie do wrong? Natalie's here, she's got a house, she's got 3 kids in school. What on earth is she going to do when she goes back to Zim? This is not fair. And so that relational component is also going to be really important. So again, I think from a GBS perspective, we're obviously very focused on helping our clients to comply legally. And of course, that has to be done correctly. But increasingly help the focus on the EQ element, the people element, how we manage this process, not only from ticking all the compliance boxes, but how we engage the impacted individuals, how we are perceived to facilitate that process is going to have an impact, not only on the affected individuals, but on the rest of our workforce who are obviously looking at that. We also need to make an assessment at an individual impacted employee level, because what is going to happen? So there are 3 potential opportunities or scenarios in my perspective. One is that if somebody is there, there is a chance they could abscond. So if there is an individual who potentially is undocumented or who doesn't want to leave, is fearful of the future, who may think, let me just disappear and pop up somewhere else later, there is a potential that someone absconds. So we've got to have a think about whether we think that's likely at an individual level, what would be the impact, and do we have a plan B? And again, this could be an area of support to your clients who may be impacted by foreign national exits. We still need to follow good labor practice. So if someone absconds, we follow the standard protocols that we would have followed in any other situation. And we ensure that we have documented correctly so that if there is a need to prove compliance, we have it. We have a very real risk of disengagement. So individuals who are disengaged because they are feeling overwhelmed, they are angry, they are frustrated, the end is coming, and this, I'm just going to plod along until we eventually get there. Now, of course, there are some opportunities around engagement strategies. We need to think about succession interventions, and we may well need to manage that exit aligned with fair labor practice. So if somebody disengages to the point that their absenteeism is unacceptable, their behavior is not in line, their performance is not appropriate, we would need to then obviously follow the correct labor practice as we would any other time. There are, of course, individuals who may be willing and able to cooperate. Now, there it might be they are hoping for a positive outcome, and where we might be able to give them some guidance around their options. And again, how you want to do this is up to you. I know some of our clients, if they are critical skills people, they are actively involved in trying to facilitate the process of application for alternatives. In other cases, it's really just about giving clear communication to those individuals, perhaps pointing them in the right direction, and maybe being a little more acceptable or lenient in terms of giving some time off for those individuals to be able to go and stand and make application at the Department of Home Affairs, etc. If these are individuals who are going to be leaving, can we try and incentivize their cooperation? So how do we help drive a continued productivity? How do we help incentivize a skills transfer or a succession process? And here, I mean, there's no one size, but potentially some kind of offer of a bonus at the conclusion of the process may be a win-win. So the opportunity to keep that person motivated, to help facilitate a transfer so that the impact of their exit is not huge from an operational perspective, and it gives some kind of financial benefit to an individual at the end of the process who is going to have to make a change. They're going to have to move, they're going to have to relocate, and all of that comes with cost. Of course, also we need to follow good labor practice, and in this instance would be an incapacity process, because the person is incapable of executing their duties as a result of their legal status. We see, and this is the reality of it, is that it's a heartbreaking situation. So these are real people. These are people who, for the most part, have been model citizens, taxpayers. They are contributors in our community, and who are facing a very uncertain future. We know that Zimbabwe has some severe challenges, in particular in terms of economics, and so what faces them is potentially going to be quite traumatic. I just wanted to touch briefly on provident funds and pension. We have seen in the last year a lot of reports in certain sectors of individuals who are foreign nationals resigning, and they're resigning to access their retirement funding because they're concerned that they wouldn't be entitled to have it once their visas are over. Now, of course, I can't speak for specific bargaining council rules. I think it would be important to go and check those. But what we do see in regards to the SARS directives is that there is the opportunity for individuals who are exiting South Africa, either as a result of immigration or the expiry of a visa, to be able to access the full value of their retirement savings. But of course, there is a process that needs to be followed in order to do that compliantly. So how do we manage it? Well, there really are only three ways. And again, I welcome if John is still with us, if he wants to join in here, but we'll also take questions. There are three primary ways in which we need to manage an exit. So of course, depending on the contractual conditions, if an individual is employed on an FTC, we can of course assess their current end date and manage accordingly. So we exit the contract in line with the obligations and fair practice. For those who are permanently employed or on contracts which are not time-bound, we would follow the incapacity process. It's a no-fault dismissal if the individuals are unable to execute their duties as a result of their right-to-work status. So we would need to follow that protocol. And then ultimately, the other option is potentially, and you would make this call depending, of course, on the operational impact, is to defer the decision. So you may consult with the individual and engage to agree to a no work, no pay, almost a sabbatical, I guess you might refer to it. It might be 6 months in which the job would remain available for the individual, provided that they could return in that period of time with the right to work in that role. Failing which, of course, it would be an incapacity dismissal. So similarly to somebody who might be injured and there would be a period of time for rehabilitation to be able to reintroduce. And obviously this is dependent on whether you could secure a temporary employee in the meantime. Again, an opportunity as TES providers potentially to support our clients who may well have workers in this particular situation. And again, we have an obligation under incapacity to explore alternatives. So that would be to obviously identify those who are impacted. What is the impact on their ability to execute the job in line with their contractual terms? What sort of timeline are we looking at? And then what kind of options exist? I mean, could we accommodate in inverted commas? So somebody whose conditions perhaps are different under a new visa, could we accommodate them in that way? Could we allow them to go away and we'll keep the job open for a period of time? And that would be dependent on if we could find a suitable alternative, if there is a temp available. And like everything, it's got to go through our labor law processes because they are entitled to all labor law protections. So formal consultations, which are documented, and of course a fair hearing, which is ultimately a no-fault dismissal with notice pay applicable. And again, just a description of the kind of process and potential for escalation in the event that there is a belief that it was unfairly managed. And to conclude, and then open for questions, there are, of course, both opportunities and risks in this process. So the due diligence is our starting point, and it's really to assess what is the scope of the risk, how many foreign nationals, and again, I think it's a really good thing to assess all, not only those who are ZEPs necessarily, to ascertain the status of those employees, to be clear about what roles they're fulfilling, what skills they have, what is the nature of their visas, durations. And again, as I said, I have a template, just an Excel template, which can help to document. And then from a governance perspective, you know, are we legally compliant? Are we in compliance with our own policies internally, which could be our employment equity plan, our diversity policies and others? And then what is the impact operationally? So how are we going to be impacted from a structural perspective? So which are the roles or areas in our business which are going to be affected? Where it's just an individual, maybe not as big a deal, except they could be a key man. So we could have a key man dependency challenge there. Where are the opportunities in our employment equity plan? Because potentially that does provide an opportunity. So we've got, from an impact assessment perspective, we've got the risks. So what happens to us if we're found to be non-compliant? By the way, you can become liable for the cost of deportation for any illegal or undocumented or documented but expired foreign workers, in addition to fines and potentially even jail time in certain circumstances. What are the operational impacts from a skills, leadership capacity, operational requirements perspective? And that opens, of course, opportunities, because if we've got people exiting our business, we have the opportunity to potentially relook the way work is working in our environment, the organizational design. We can also have a look at how we might maximize the replacement of those individuals. So how could we use this to help support our employment equity targets or our BEE targets? Could we take advantage of things like the ETI in bringing in young people into these roles? Now, again, depends, of course, on the nature of the role and the skills. What kind of skills transfer could we put in place, ideally to maximize the value of the individual's experience and knowledge that while they're still with us? And then, of course, from a compliance point of view, what do you need to do? So what are the things that you need to do to mitigate liability and ensure conformance? How do you make sure that you regularize your employees if they're not currently aligned? How can we optimize employment equity and BEE simultaneously? And of course, we can drive competitive advantage in this process. So by building future fit operational structures, which are prefaced by having skilled and productive workers. And then very important, the transitionary phase, because it is going to be a process in order to comply. The difficulty is that without a certainty that absolutely on the 30th of June they must leave, there is a possibility this might extend longer. And so we need to have a plan of action. So how are we going to engage? And this is a communication plan beyond simply only those who are directly impacted. I think it's something that needs to be addressed at a holistic level, given that other employees are going to be watching what's happening, and there is a potential for unrest or unhappiness or disengagement. What is our transition plan? And how do we communicate through that process? What are we doing about succession planning? So can we identify individuals within our business who we could potentially fill those gaps with? Do the skills gap analysis so that we can put in place a skills transfer training and development, a formal transition succession plan, and then how do we help exit and support those individuals who are impacted? So those who need to exit, can we ensure that they are fairly dismissed and enabled as far as possible? And then how do we help the successor to be successful, given that there may be a very short window of time in which they're going to have to step up to the plate and take on roles and responsibilities that perhaps were outside of their space. Okay, thank you. So that's all the content. I appreciate I've been talking non-stop for an hour and a half. I hope it has been useful. We still do have some time. I'm not sure if there are any questions. Happy to take them directly, or whether that you want to pop them in the chat box.
Natalie, thank you very much for this insightful presentation. And, you know, Gordon has a question for you. What are the fines for non-compliance in relation to employment and of undocumented foreign nationals?
My understanding is they stretch into the millions, LB. So I think it depends on the nature and number of the scope of transgressions. I just want to go back. I think there is a reference to the fines. I will go and look in the Immigration Act, but it is, I mean, the fines are potentially in the millions, but the HR executive could be imprisoned for up to 5 years as well. So it's not just a financial risk, but potentially a you know, a legal and incarceration risk as well.
Wonderful. Natalie, then the question that sits in my mind, and that I'll keep on thinking about your Congolese lady, that is the architect, etc., etc. So what if the local SME makes this person a knowledge worker, and let's say in a perfect world, she's got all of the infrastructure to work from the Congo, do her work, but the work is done for the South African company. How's that going to be managed? How's it going to be controlled?
So I think it's a really interesting question, Albie, and I'm not a lawyer to be able to provide you with a legal opinion there, but it is one of the suggestions that I did make to this particular client, is to say, you know, is there not the possibility that she could execute those duties from inside of the Congo, and where she would be potentially contracted as a provider or a supplier? Because again, I think the cross-border employment issues are not yet very clear. And part of the national labor migration policy is this recognition that we have this situation where, you know, we might have a South African sitting in Durban working for a US company, and where theoretically they should be governed by South African laws, but we know that the US company is going to operate as they operate and may hire and fire as they do. And conversely, we have foreigners who are not sitting in the country, but who are providing services or skills and knowledge into a South African entity. So part of the national labor migration policy is, I think, trying to get their head around these so-called platform workers. I think it would be important to ensure that an engagement like that, if it's possible, I mean, it would be one of the most logical ones for me, is explored to make sure that it is correctly structured. So I'm not sure that you could be classified as an employee and paid as an employee on the payroll, because I presume that whether you're working here or working abroad, there would be legal implications to the labor relationship or the employment relationship, but potentially contracted in a different way.
Yeah, it sure is interesting.
It works for knowledge workers, but of course, if you've got a mechanic or you've got a refrigeration technician, unless he's where the fridges are, it's not going to help your case.
It's not going to work. Then the last point from my side, the mining industry. I mean, historically, the bulk of the people that we've got, well, it's a broad statement, but let's put it this way: a large quantity or percentage of the people that we do have working in our deep level mines, or most of our mines, are people that are migrant workers from countries like Lesotho, Botswana, Zimbabwe, Mozambique, even Malawi. You know, it would be interesting to see how that affects the mining industry if this goes ahead.
Absolutely. So again, I think there are certain nuances in certain sectors, particularly where there's been a traditional kind of talent generated by a space, is to have a look at what is the conditions of those visas. But I think that they would presumably be on fairly long-term work visas, so the problem may not be immediate. But if we continue on this trajectory with a government that's saying we need to put South Africans first, we have a chronic job shortage, I suspect that we're going to start to see even those areas and visas slowing down. I think what isn't in here, and which I actually just read this morning, but I think is important to recognize, is that there is a significant backlog within the Department of Home Affairs. There's the excuse of COVID in some instances, which I suppose to an extent is real and acceptable, although I believe there were quite a lot of backlogs previously. And so the timelines for the assessment of visas is getting longer and longer and longer. And as we've seen in the example of the Congolese architect, I think if somebody has a visa which is coming up for expiry, we can't leave it too late. I think sooner rather than later is better to explore a renewal or an extension, because otherwise you sit in that precarious position where, although I'm waiting on the department, what happens if they turn me down and I then exit the country and I'm suddenly deemed to be undesirable because there isn't a fair consideration of why. I see there's a question from Zehlobo. Having discovered that an employee's identity is being investigated by DHA courts but not blocked, could the relationship continue? That is interesting. I need to think about that one, sorry, and probably check in with one of my legal colleagues to get a sense on whether that would impede your ability to employ them. It might. I'm just trying to think of, it's the same as we've seen, for example, case law around somebody who's been incarcerated, waiting trial, and where an operational requirement, incapacity could be used to terminate that individual. I guess we need to get some indication, and it'd be interesting to find out whether the department has in fact come to the employer, etc., to raise that concern. Unfortunately, what we see with IDs is that it's not necessarily this person who is the problem. Somebody else may have utilized my ID. So I guess we'd have to be very careful about what is the nature of that query. Is it that someone else is using my ID and it is in fact mine, or whether I am the foreign national who is suspected to be in possession of an ID that is not mine? Are there any other questions?
All right. If there are any other questions, Natalie, thank you once again for you and Global Business Solutions for the support you give us in these webinars as the TSD, and the knowledge and that you impart with us. For those people on this webinar that are not members of the TSD or want to find out more about the TSD, you are more than welcome to contact Krista Smith. Krista, if you could just put those details on there, that's her cell phone number as well as her email address. And we're happy to look at your questions and assist you where you can. But once again, Natalie, thank you so much. It was extremely appreciated, and I hope all of us that participated in this session has taken something home. that's made us think and will future-proof us for these changes as well.
Thank you. Thank you, everybody. Have a good week.
You as well, Natalie.